We did yesterday afternoon about this initiative, and I will be detailing the activities later on. I would like to emphasize that yesterday you talked about a preliminary identification of the possible achievements or possible commitments that we could want to take to the high-level meeting next year. Today, we will be analyzing how to work or how to use this tool of zero statelessness to reach those results and try to identify the possible commitments. Today, then, the emphasis will be placed on the program and project design, the experience of the countries, design and project implementation, and the work in identifying how you believe we can support at national level the design and implementation of projects. I will be introducing the initiative towards zero statelessness, and Ana Paola will be talking about the indicators. As you well know, and we remembered this yesterday, the Brazil Plan of Action is the strategic regional framework that includes a program of eradication of statelessness. Chapter 6 on eradication of statelessness includes or talks about the different actions that the states would want to implement in eradicating statelessness. So we reviewed the different actions, the determination of statelessness, the ease for naturalization, birth certificates, and others. These are all the actions that we hear in chapter 6, or we see in chapter 6. But then we have a chapter 8. It is of the plan of action that is related to the implementation and follow-up. This is about projects and evaluation. The language used for chapter 8 is that once the states have defined their priorities internally, they will elaborate specific projects with the collaboration and technical advice of UNHCR. They will be working in the creation of the implementation projects, and on the other hand, they will explore the need to create assessment or evaluation and follow-up mechanisms for this plan of action. The idea is that each state, with regard to Chapter 6 of Eradication of Statelessness, they will see what it is that they consider relevant internally. If a state is not part of those actions on statelessness, that becomes relevant. If, for example, they do not have a protection law, that could also be relevant, maybe not a priority, as Peru did in 2011, that they had two commitments in the ministerial meeting. They considered accession and a regulatory framework, but they considered it was a priority, the accession. So what a state has to do, and what Plan of Brazil is proposing, is to define the priority actions. Then the projects in its design and implementation, then comes an assessment stage and a progress report. As you know, this is done every 3 years, and it is done with the UNHCR together with the different states, and the UNHCR has to draft a final report. In follow-up, the logic here is to implement, assess results, and report them. What is towards zero statelessness? It is a proposal, a suggestion that UNHCR has presented to the states under Chapter 8 of the Brazil Plan of Action as a mechanism to assess and follow up Chapter 6. It is only related to Chapter 6. It is a specific program in the eradication of statelessness. Towards zero statelessness, you have the document in your files and also in your pen drives, and it is created based on the strategic framework. Of course, it is the Brazil Plan of Action, but it is aligned to the global plan of action to eradicate statelessness. The background of this document: the exercise of assessment that was carried out last year in assessing the Brazil Plan of Action, UNHCR, together with the IPPDH of the Mercosur, created some progress indicators that served in the assessment of the advances of this plan. These progress indicators, if a state, for example, has a bill or if there was a law that had been voted, all these advances have been taken as part of the indicators and be used for the initiative towards zero statelessness. And of course, we have also considered the best practices at regional level in the creation of the standards that you will be seeing in the indicators that Ana Paula will be talking about later. Therefore, standards are not only based on international standards and the minimum standard, but also the best practices at regional level identified by the states themselves. Now, which is the objective towards zero statelessness? Of course, to promote the implementation of actions of eradication of statelessness. Of the Brazil Plan of Action is the first objective. Then, to be able to promote interagency work, the UNHCR together with the state, with the civil society, with stateless persons, to ensure that we can jointly work, that the states will receive technical and financial support from UNHCR as it is needed, and also to promote development and implementation of projects that have low cost but high impact in terms of the different actions of eradication of statelessness. And finally, it is also a way to promote a monitoring system, a joint monitoring system of eradication of statelessness. For example, this means that certain supplies can be created in helping with the report of the achievement. Which are the benefits for a state to be part of this initiative, of this towards zero statelessness plan? The first thing is that we will be presenting regional indicators. All states that on a voluntary basis decide to be part of the initiative, they will be able to measure, considering this very same basis, which are the achievements in terms of eradication of statelessness. Then there is a participatory assessment mechanism, meaning that when we jointly assess UNHCR together with the states where we're standing, they will be participating in the civil society or maybe other interested parties, even with stateless persons. What this program does is to provide international recognition to champion countries. Why? This is a way to make evident how much there has been in terms of advances, in terms of eradication of statelessness. As part of the program, we have recommendations provided to the different states if, for example, they don't reach a certain standard, in such a way that there can be a suggestion or maybe a guidance towards actions that can be taken in terms of advancing in this agenda. It also improves understanding of problems related to statelessness. Many times, to assess what the problem is and to understand it better will help in this activity. It also aids in the identification of priority actions at national level. And as already mentioned, it is a facilitation of the design and implementation of national projects. It also provides inputs for UNHCR country operation plans. We will be talking about these country operation plans later on. It basically defines what the work of this office is doing in a certain year of work. And as I mentioned earlier, it facilitates the report of progress every 3 years, and it also supports the Sustainable Development Goals of the United Nations. For a state, or this initiative is based on a voluntary basis. It is a proposal that we have as UNHCR. But for a state to be able to participate, they have to officially communicate it to the UNHCR. For example, in the case of Costa Rica, the government has to contact the UNHCR office in Costa Rica. Which is the methodology? The proposal is to be able to gather information of all indicators to have an initial assessment that will present sort of like a picture of what the country is or where the country is at the moment. And this information gathering is done based on the state's information coming from the pertinent departments or agencies. If, for example, we're going to assess the information related to birth certificates, it means that the National Registry Office is going to participate. The government will have to consider which is the focal point that will serve as liaison and will gather the official information. And of course, the reports that could be available from international organizations, including any agency from the United Nations, will be considered, as well as the civil society information. This whole information provides an initial assessment that allows the state to know where they are standing in terms of the indicators presented. And it will include certain recommendations, and it will provide a certification. The certification does not mean that it is issued when a country ended statelessness or when the country becomes a champion country. No, it is every time there is a report that can be drafted on a yearly basis or biannually, the state will take this picture of where they are standing. That is sort of like a certification of their status. What is expected is that this information coming from the assessment serve as a basis to create a design of projects. The state that wants to work with certain actions discusses this with our office, and it will be a supply for the design of the operation of UNHCR at national level, and it serves as a design for national projects. The national project maybe is a project of confirmation of nationality, and Delfina will be talking about the experience here in Chile later on. Colleagues from Costa Rica will be talking about the experience in Costa Rica, but the idea is that we need to have certain projects that will be able to obtain achievements. The role of civil society is on a participatory basis to provide information of indicators. And of course, our desire is that design and implementation will come together with the civil society whenever needed. Once we obtain this preliminary report, we share it with the state. This could be observations. The mechanism is very similar to any human rights mechanisms. Within the framework of the United Nations, there can be observations presented that will be incorporated in the report.
Finally, we provide this certification, and it could be that a state at the beginning in terms of the certification can show that there are still many other actions to be undertaken domestically, and this initial certification allows through time to measure the progress made. I would like to underscore this. The UNHCR, under the Plan of Brazil, is going to urge all the countries to implement actions for the eradication of statelessness. whether the country desires to become part of this initiative or decides not to accede. The UNHCR will always provide the financial and technical support in order to implement projects. What we would like to propose as an agency to have a common approach for the region to all countries and can have all these benefits I explained before so that we can multiply the possibilities of getting funding as well as support for the development of projects. So this is basically the logics behind the concept of what our proposal is. And we expect that you can consider in depth this document and this proposal and eventually join in order to work under this logic of work. I would like to clarify that the certification is something that can be jointly with the Office of the UNHCR, and potentially we can also support hiring consultants nationally or abroad to support the organization of this work. And in some cases, the states may decide that this person is a third party independent and they make part of the national commissions for the refugees or other alternatives, and this is something that we can discuss by bilateral way with the countries, and at the beginning we could have this kind of support initially, and if this capacity is not already installed in each one of the countries. I don't know if you have any questions. Soledad. Thank you. I wanted to know if these mechanism and the eventual certification are public, if the results are disclosed amongst countries, or this is only something bilateral between the states and the UNHCR. The idea is that the information is publicly available. When we'll see the indicators, we'll go into the details, all the standards for the information, and we'll see whether this information will be public. And we'll see how we're proposing this production of standards and indicators. I would like to highlight once again that this is a mechanism that is completely voluntary, and a state may decide to join in or not, and this is not an alternative to Brazil's plan, but this is under this plan, and the idea, I underscore, is to double the efforts and to help you in obtaining results for the eradication of statelessness. And the UNHCR will continue to support the countries even though they do not make part of this uh, project or this plan. Ana Paola.
Bueno, muy buenos días a todos y todas.
Good morning, everyone. As Juan Ignacio said, my presentation basically will be on how we're going to do the measurement and the indicators, what are the standards that will be assessed regarding each one of the expected results. So first of all, in here we have some general characteristics concerning the indicators, all kind of indicators. As Juan Ignacio said, many of you were involved in the 3-year assessment for the Brazil's plan, and it takes as a baseline all the indicators that have been developed by the UNHCR and the Institute of Public Policies on Human Rights. We can say that this is a continuance of a work that is already undertaken. This is common to all the countries of the Americas, which allows a uniform manner to measure progress, and it can since they are the same indicators, we can show what the regional progress is. Each indicator reflects the respective standards developed in the human rights treaties, and that is to say the Convention of 1954 and 1961, the Convention of the Rights of Children, the Inter-American Convention, and some other covenants, as well as the standards developed in the Inter-American system, that is to say the Inter-American Court of Human Rights, and they take into account the legislation and how it operates in practice. That is to say not only evaluation of what the legislation provides for and whether it is applied and how it is operating, and practice will always prevail. And some of the indicators, particularly for the birth registration and the bestowal of certificates, will have some percentage data as well as number or figures, and in order to give a comprehensive detail of the situation in the country. And this is a contextual kind of information. As we'll see later on, there are some sheets of evaluation where we have the indicator of impact that measure whether the impact is taking place and whether the state is meeting this requirement. And these are the actions that the government has undertaken to materialize the results that are expected. And I will explain in each one of the indicators what these impact indicators are and the progress made. Yesterday, we reminded you the actions from both plans, that is to say, the World Action Plan and Brazil's Action Plan. They are targeted to 3 major objectives, that is to say, identifying and protecting the stateless person, preventing new cases, as well as resolving the existing cases already for statelessness. The indicators are grouped together in these 3 or pillars or segments, and we're going to provide 3 indicators for each one of the groups. On your folders, your papers, you have the annex for this evaluation mechanism. And this is what you are going to see. Basically, you can observe here that on this place we have different actions of the global plan with Brazil's action plan, and this is mm, translation at the regional level and an indicator by each one of the actions. So we can say that they are grouped together according to protection, prevention, and solution. And this is a very straightforward mechanism. We try to make it as simple as possible, and therefore there are just 9 indicators and 9 concrete results, and we expect that the state gets these results. Each one of the indicators has a sheet of evaluation and will do the measurement of the progress. And how are we going to do the evaluation? Through this evaluation sheet that will take into account all the inputs given by the state, the civil society, and even the stateless people, as Juan Ignacio explained. We intend that this is a joint evaluation articulating or linking together the different players. Each one of the indicators has this evaluation sheet, and we can see that this is the structure. First of all, on top you have the indicator, the info of the indicator, and the expected result, the action from the Brazil's action plan, which is relevant to the result pursued, the objective of the indicator, and basically this is a measurement scale. That is to say, based on the diagnosis that we contact, we can see under which category the country is located, if they have made progress in this matter. And here we can see a few items that should be improved. That is to say, a situation 50-50. And in this other one, we can see that virtually no measures were taken. And here we can see how the measurement is done for this indicator. And then we have the part regarding each one of the standards. We have the evaluation of these evaluation, and we can see each one of the items. Then we see this evaluation sheet that shows the frequency for the compilation of data and everything that will be taken into account for the measurement, the frequency of the report. And as Juan Ignacio said, depending on the chapter 8 of Brazil's plan, it should be done every 2 years or 3 years. The deadline can be shortened, and we have the progress indicators that basically are the steps that the country has taken, although the state has not yet obtained the results. But these steps were, however, taken. Everything is concerned or contained in these indicators. By group, I will explain each one of the indicators. Indicator number 1 consists of these characteristics. If the state is party to the Convention of 1954, and then if they made all the reserves or has taken the steps. And then we have indicator number 2 concerning the procedures for the eradication of statelessness, that is to say, or determining rather the statelessness, that is to say, if they are accommodating to this process and if they are fair and efficient, that is to say, not only if they are doing a thing, but rather how they do. Then we have the standards for the ordinary procedure, and they take into account the special procedures, that is to say, children, teenagers, adolescents, and the people with disabilities. This indicator also considers the coordination with other procedures, administrative procedures, as yesterday Jose Carlos alluded to. We have in the case of Costa Rica, they have the coordination with the civil registrar to see whether they can declare a person who is stateless, and if this person is eligible to get the nationality. They also do all the requests for asylum in case it's relevant, and if the person who is a refugee is stateless, will be protected under the Convention of 1954. And this indicator takes into account all of those items concerning the procedures. So another thing about this indicator number 2, although a country still doesn't have the procedure, which is likely to happen if they are in the process to get and is getting all the technical advice to the UNHCR, this will be considered as a progress made. And indicator number 3 consists of the regulation frameworks guaranteeing the effective protection of the stateless people, and this indicator is going to measure the standards contained in the Convention of 1954, as well as other standards that have been developed by the Inter-American Justice Court. And then we have the administrative detention, that these people are not detention as stateless, and then the issue of the stateless refugees. The indicator of progress, or one of them, would be in case that the state has not adopted the law or bodies already negotiating this law. The second group of indicators are the prevention ones. The indicator number 4 is similar to number 1, but based on the Convention of 1961, whether the state is part of the convention and if they have reservations. Number 5 now, if in the legislation and the practice are compatible with the international law. And here we can consider, for example, the Convention on the Children's Rights, the Convention of the Elimination of all kind of discrimination against women in 1961, and it measures whether the state is applying the safeguards of this convention as well as other jurisprudence development. And we have all these safeguards concerning these issues, and the law should give the same rights to people independently of their gender and other discriminations. And this would concern the acquisition, loss, deprivation, and other issues of nationality. Indicator number 6 corresponds to the birth registration, and this indicator reflects basically if people that have not registered yet may face risk of statelessness, or the content of this indicator is the timely registration and the late birth registration, as well the registration abroad.
Destacar una
I would like to highlight a practice from Mexico. They have the late birth registration in consulates. It's quite a useful mechanism used in the region, and we hope that other states can replicate it.
Sobre el último mecanismo, perdón, el último grupo.
The last group would be resolution. Indicator number 7 is related to migrant stateless persons and the facilitation to naturalization, meaning that if the state provides good possibilities, Article 32 of 1954 Convention does not establish a list of facilities, meaning that it is quite a flexible indicator, and it only measures whether the state provides any possibility of aiding and managing the help to stateless people and be able to obtain their naturalization. Indicator number 8 basically measures the provision of documents, whether people have the right to obtain a nationality if they can acquire documents. Basically, the standard measure this for nationals and stateless persons abroad or within the national territory. The last indicator is related to those people that renounced, lost, or were arbitrarily deprived of their nationality and how to recover it. In case of those people that lost or were deprived of nationality is if the state has any mechanism for them to recover it. In the restitution of nationality, if it is done on automated basis, which are the standards of the Inter-American Court, and whether they have access to any documentation that can prove their nationality. At the end, each assessment or final evaluation will tell us which is the diagnosis of the status. If it is a state that does not comply with the standards, if they comply with most of them or all of them, and it would mean that this is a champion country. This would be an international acknowledgement to states, and as UNHCR, we would like you to participate in this assessment mechanism. If you have any doubts, of course, we can help you. Any doubts or comments? Yes, I have a doubt. It's very practical, and I guess it was explained in the guideline.
Por ejemplo, en las
For
pruebas de
example,
evaluación,
for
según cómo se
the
da la
assessment
medición,
sheets, how
estándar,
will this
avanzado,
be
intermedio,
measured? Standard, advanced,
crítico.
intermediate, or critical?
Para que se llegue a la conclusión de que el
So
país
to
campeón,
reach a
¿cómo va a ser
conclusion or establish that our
según, por
country
ejemplo,
is
si
a
alguno de los
champion
indicadores
country,
del país tiene
in
un
the
estándar,
indicator of the
intermedio
countries,
o
if there
crítico,
is a
¿cuál
standard,
tendría que
intermediate, or
tener? O sea, tendría que
critical,
tener más avanzado,
which would
más
it be?
intermedio,
Either
ninguno
more
crítico.
advanced,
¿Cómo
intermediate,
sería?
critical? How would
Estándar.
that be done? Standard.
Cumplir con todos los
It
estándares
would have
para
to
ser un
fulfill
excelente
all
campeón.
these
O sea,
standards
no
to
tendría que
be a
tener
champion
menos
country.
avanzado. Por ejemplo,
So
en el
there's
tema del
no
número uno,
possibility of having one or
ratificó
others.
salió con
So, for
reservas.
example, if in number one it was ratified but with a certain reservation, well, it could not be fulfilling all the standards, but it would be there would be an observation recommendation to be able to reach the standard. Thank you.
St. Vincent and Grenadines, good morning.
San Vicente y Granadinas, buenos días. Estoy intentando entender esto.
The evaluation sheet structure,
La hoja de evaluación, la estructura, la información
given to us.
que acaba
You're
de ser
expecting us to do
entregada,
that on behalf
¿están
of all
esperando que
states?
nosotros lo hagamos en
No.
todos los estados ahora?
Es un mecanismo meramente
It
voluntario.
is a voluntary
Y,
mechanism,
pues, se puede ver de qué manera se
and
pueden
we
realizar
can
las
see
mediciones,
how
si
this
sea
measurement
por
will
parte
be
de un
done,
grupo
whether
determinado del Estado,
through a
o
group
algún
coming from the
consultor
state or maybe a
que
consultant,
ayuda al grupo que pueda
or
realizar la
with
evaluación,
help
o se
from
puede
UNHCR. This can be directly negotiated with the state and the resources that they might have.
Thank you.
Gracias.
I mean, just to be clear, if you
Solo
feel
para
like showing
estar
this
claro,
mechanism,
si es que
we
este
will,
mecanismo
be
quieren
happy to
mostrarlo,
support
nosotros
any way
estaremos
the state
felices
can
de
help us in
apoyar de
terms of
cualquier manera que el
maybe
Estado
hiring
quisiera hacerlo,
external
ya
consultant
sea
or maybe
contratando un
also
consultor externo o una consultoría al gobierno para hacer este tipo de evaluación por sí misma.
We have different alternatives.
Tenemos distintas alternativas, por ejemplo, para el caso de Argentina y Chile, estamos ya trabajando en términos de realizar una evaluación con
And of
un
course,
consultor
we
externo,
might
pero por
also
supuesto,
consider supporting hiring an official to be working under the, I don't know, maybe under the authority of a National Refugee Commission or other relevant agency. Okay. No sé si querés presentar mejor para que se vea más claro ahí, porque no sé si no hemos distribuido las hojas de evaluación,
the
porque eso
evaluation sheets
imprimirlo
yet,
sería
because to
como
print them
un
it
montón de
would
hojas.
be it would take too much paper, so
No está en las
it is not in your files or in the pen drives. But if you look this way, you can see that the impact indicator on procedures that are fair and efficient are divided in 42 standards. If the state has the 42 standards, they fulfill the standard completely on 100%. If they have 32 standards, but less than 42, they have an advanced mechanism. If they only fulfill between 21, 31 of the standards, their procedures are intermediate, and when this procedure is under 19, the situation can be critical. It is important to mention that there is no standard more important than the other. Okay? This means that it is not important to have an appeal system if there is information that is supported. Everything is considered equal. Another important element is what the certification will be showing is where the state is at that moment. If a country, considering all these indicators, has all the standards fulfilled, meaning a perfect system, if you wish. In practical terms, this rarely occurs in most of the countries. Maybe we can have advanced mechanisms, but not necessarily 100% of them. So what we have tried doing is to try to reflect the standards that are applicable, but also be aware that the procedures can be advanced without being perfect. When a state does not fulfill a certain standard, the report of that indicator will express that it does not fulfill the standard and will recommend that if the procedure has something that is not complete, it would say, okay, you do have this action, but you have to have more support. Same thing, for example, if there is a procedure that does not have a review mechanism, to consider the existence of a review system, either from the management point of view or legal. It was also mentioned by Ana Paola, but I would like to repeat this. For the case of asylum procedures, or he corrects himself, the statelessness and frameworks, the standards were developed based on this publication that I don't know if you saw it, but it is what we call the draft of articles on stateless persons. We have them available in English and Spanish. The proposal of the office that was discussed together with the states of the region, it is like a model law. The procedure standards are reflected here. Same thing with legislation. I would like to mention a caveat. I tried to mention it at the beginning, but I would like to emphasize it now. The system of indicators and standards is done not only from the basis of the minimum legal aspects, but also based on good practices, and with an example. If you consider the procedure manual of the UNHCR, that black book that you have there, you will see that the recommendation is that stateless persons that are recognized as such, the minimum is for them to obtain temporary residence in the country until they can obtain their naturalization. Many countries in the region, in their bills or the approved legislations, provide permanent residence. Permanent residence. So the question here is there a standard that residence has to be permanent? The response is no, but it is a very good regional practice. It is not seen in the Convention of 1954, but some of the standards have been based in the good regional practices. This is why we're not saying that a state, to be able to have an advanced procedure, should have the 42 fulfilled procedures. Maybe a state will provide a temporary residence for 2 years, for example, and that would be correct from the point of view of international law. The standards are based in norms and good practices at regional level. Something else I would like to mention is this system is not in practice yet, meaning that this is the initial stage. We are right now proposing you to participate in this initiative. As there are countries that participate from this initiative and they want to be part of this assessment or evaluation system, we'll start testing how measurement works in practical terms. What does this mean? That indicators can be adjusted according to the experience that we obtain in the evaluation exercise. And something I would like to again clarify, if from UNHCR with the different states we decide to take out, add, or modify a standard in any of these indicators, it will be applicable for all countries. This means that we will not modify an indicator so that one specific country can reach one place or another. This is a regional system that can be adapted to the different countries, but in terms of indicators, this adaptation will be for all states. We agree on this? And I think that by enlarging this view, you can see what we tried to mention. you can see that this is the standard for efficient and fair. There is a fair and efficient procedure to determine statelessness. The first thing that this procedure measures if there is a competent authority for the determination of statelessness. So, is there an authority that determines who is stateless? Yes or no? That is the first standard. For example, those people that require information about stateless, whether they have the information or not, is there a specific peremptory term for the submission of the application, yes or no? Can the procedure be initiated ex officio? If the application can be submitted in different areas of the country. It doesn't matter which is the migration status of the applicant, but they can request this naturalization process. So as part of this analysis, you can respond yes or no, yes or no. And finally, we know where the state is standing in terms of this indicator. I do not have here with me the indicator of the Convention 1961 or 1954. But you can see that the situation is critical when a state is not part of any of these conventions. It is acceptable, of course, when they are part of this, but if there is a reservation presented. The ideal here is to be part of the standard, but without any questioning. If the convention is allowing certain reservations, then there can be an expression about this. We're not saying be part of the convention with these questioning, but if, for example, in the case of Mexico, where they have an article of the facilities to naturalize, it is possible according to convention. And of course, we have the recommendations to consider this, but it means that if it is not done, then there's no fulfillment of indicator.
That is more or less the spirit of this system. Nisha, tengo una... ¿Tiene que usar el micrófono, por favor? Simplemente me preguntaba acerca del plazo que existe para los países que se interesan en unirse a la iniciativa. Esto es una iniciativa que nosotros esperamos tener para los próximos 5 años de la campaña. Una vez que un Estado informa al ACNUR
we will give a term to try to gather all the regular information to conduct the assessment within that term. But of course, if for any reasonable justification, the state might need some additional time, of course, we will provide that additional time. Because after all, the idea is to work together to assess. This is not this is maybe the difference with the formality of the mechanisms for review human rights under the UN system. Where, for instance, in the case of the UN Committee of the Rights of the Child, of course, you have a deadline to provide the national report. This is not, I mean, this is different to that. Sí.
I have a question that I share with my colleagues from the government. In order to have this form, do we have to wait first the request by the states with their willingness to participate, or we already can count on this to start working? We can share with you these indicators, and state would also have the option to observe and review these indicators before joining in and to see whether they are interested or not. Of course, they are readily available for you. The evaluation. Since the logics of this work is regional, the evaluation of the indicators is jointly between our regional legal unit in Costa Rica and the concerned offices, as well as the countries involved. And this would allow that the logics of evaluation is not just from one single determined office, but that of the UNHCR. And of course, at the regional level, we can do that under a consultation with the section of statelessness of the UNHCR in Geneva. I don't know if you have any further questions. Thank you. First of all, I would like to thank you for the presentation, that it was very illustrative. And I have two questions. The first one is how this mechanism is related with the meeting next year. Because we are discussing here this high-level meeting. As I mentioned yesterday, I think that the objective of this meeting is seeing into how the states are moving forward for eliminating the statelessness. And I would like to know how this can be a tool for the meeting next year. And the second more specific question is regarding the criteria, the criteria for evaluation. More specifically, here what we have on the screen, number 7. If an application has been submitted in written or orally. My question is whether this comes from the text of the conventions or is rather a criterion that has been thought by the UNHCR, and that not necessarily comes from the legal text. I don't know if I make myself understood. Well, thank you. Thank you very much for the two excellent questions. And how this relates, this initiative relates with the preparatory work for the high-level meeting next year, and the country that eventually has the initial evaluation done based on these indicators will know very clearly what the gaps are or what the areas are where they need to work still to reach the proposed standard. For example, this will let them know whether the procedure for the determination of statelessness is fair and efficient, and to know whether they are also facilitating the mechanisms for naturalization. This allows to identify the existing gaps, and based on that, the state may desire to identify the action in order to fill that gap or to benefit from the financial support of the UNHCR to respond or palliate the situation. And if this occurs next year, that is, identifying the problem and to approach it from a project and solve it in terms of results, it will be presented next in the high-level meeting. Likewise, the state would be able to identify different gaps, and due to the time constraints, they will be able just to work on one issue to submit it in the high-level meeting. However, in this meeting, they can commit themselves us to continue working vis-a-vis the next issues. And this allows to render visible the situation where they are standing and where there are some possible areas for further work and where they can receive the support or the technical assistance from the UNHCR to tackle these projects. In a certain way, they could either support this high-level meeting, and that's why we are presenting this instance to present this initiative. So I would like to underscore the idea if a state want to benefit from the support of the UNHCR, but not being part of the initiative, this agency will provide full support to the state to move forward with a joint initiative. And what we are trying is to provide the states with a tool according to what they decided to say under chapter number 8 to have this mechanism of evaluation and follow-up, and this is completely voluntary. And the second question, in the concrete case of standard number 7, if the application should be submitted orally or in writing, when the text of this convention of 1954 doesn't provide for that concerning the procedures. Each one of the states, based on their constitutional status and the administrative status and their legal apparatus, can propose the system that is more suitable. And there are some standards, as Ana Paula says, that we have taken from used to be a standard for the conditions to determine the stateless status. There is this possibility to request this orally on the border, and after the procedure can be in written. Then we have the jurisprudence of the Inter-American Court, and this should contain this possibility in the context of the procedures for refugees. And we have the draft version of this article that uses these logics, that is to say, using the standards of procedures of the system for the asylum of refugees. But concretely, the convention doesn't say that this should be either in written or oral. It doesn't establish everything and doesn't regulate specifically this item. Juan Ignacio, when I consider this instrument, and as it was explained, I think this is an initiative. I'm speaking of Latin America and the Caribbean. Any country that is developing the procedures for statelessness, I think that they could not be apart from this initiative. I'm concerning now the instrument. This is a question I have. I don't know if what you're showing now is a template explaining the instrument, or is the instrument itself the form that should be filled out, because I'm thinking in the case of Chile, and maybe it happens to all the countries in Latin America, many of the answers will not be either yes or no. So there are many points where the questions can be partially answered. So I would like to see how you have envisaged these alternatives of partial answers when filling out the form. Thank you very much. This is a very good question, and the answer is that we try to simplify many of the standards, because sometimes the answers are not either white or black, and this will depend on the specific considerations and the standards, and if we see that in practice the standard is met, although the formulation is different, we will make a decision by establishing a regional standard on whether these can be met or not under specific circumstances. That is on one side. Then we see the standards of the indicators that would indicate if there are some procedures to determine the statelessness that are efficient and fair. Based on the standard, it's very simple, and you say if it doesn't meet the requirements, because there are no procedures in the countries. The countries that today could evaluate this, the compliance of the standard would be Mexico, Costa Rica, Brazil, Ecuador, and to a certain extent Honduras and Nicaragua, because they don't have a specifically regulated standard, but they do have an assigned authority under the law to conduct all these procedures. But most of the countries will answer no. If I ask Argentina if they have these standard for the determination of statelessness that is fair and efficient, they will say that they don't have. They have a draft bill, and this is not in fact fulfilled. And we could have situations where, in practical terms, a country does have a mechanism and they do not have a law or a procedure, but the Convention of 1954 applies when analyzing the cases, and we will consider that. However, in this context, the recommendation would be that if eventually you conduct the evaluation and you are able to determine the condition and you document this person as stateless, and you give an identity and you give the legal residence as a humanitarian reason, this country is actually meeting many of the standards, fulfilling this requirement, and will recognize this, acknowledge this, although the country doesn't have a law or a specific procedure to determine this situation. So what Ana Paola said is that you are going to consider the law, but more specifically the practice, although the standard is met, but in practice we have this information that is trustworthy. The answer will be that is not fully met. So in this case, Juan Ignacio, you can say that the standard is met de facto, and then there should be a legal formalization. I'm sure that this system will be improved, and you will say that this is liable to be improved. But this is the initial proposal. As other countries can work on this tool jointly, this will be a benefit for everyone. This is similar to exercise we did with the draft of articles that was referred to as a model law. If you see the document of the UNHCR for statelessness, and you see the draft back from 2017, you will see that there is a whole difference concerning the different items that have been introduced. We had already 2 meetings with the countries to discuss this document, and many of the contributions come from the countries.
Therefore, it is precisely from the contribution of the countries that these tools can be improved. It is our hope that we might have in the following months the participation of interested countries. Are there more questions? Good morning. Is this information in the system? No. No, we don't have it yet. Maybe at some time, at some point we will have it online, but right now, no.
Gracias.
I have a doubt, or yesterday we had a doubt when talking this afternoon, and that is related to criteria. The use of terms that might be subjective. For example, when talking about an efficient procedure, who would be judging this? How is this being assessed in concrete terms? This will be in different criteria of the mechanism, but specifically in that area. An efficient procedure is what we are concerned with. What would that be, and how to assess something of this nature? Thank you very much for this question. With regard to indicators, we took the language of the Brazil Plan of Action. It is language adopted by states. The fair and efficient notion comes from a language that is quite frequently used in those documents related to procedures of determining the condition of refugee, and it is there where the states have taken this amount for. And of course, I do agree that it is an indeterminate legal term. It is understood as fulfilling the minimum standards of the due process, same as it is in the Inter-American Court. And efficient, maybe the concept is less defined, but it is related to. It should be able to respond on a timely basis to the amount of cases presented with regard to the number of applications, for example. Now, without wanting to define efficient, because it is not the logic of this document, what we have said is, if the state complies with these indicators, we in general believe that the procedure can be considered fair and efficient. But I am sure that if we here want to see what is fair and efficient, maybe then we would need to add 10 more standards, or somebody says, no, let's pull this one out. It is part of the exercise that we would like to clarify right now. We are open to this as long as this can be done with a regional criteria that responds to improving the tool. It is not necessarily what this is. So after using it with 4 countries, we see that elements have to be improved, then this will be done, and it will be done according to the experience of certain people and also the civil society. But this, of course, is by now the proposal and probably can be perfected. Considering fair and efficient, just mentioned by the colleague, is this also related for certain legislations that is quite good, but there are barriers to access, meaning that there is a barrier to effective access. So if we find that there is something related to barriers or a lack of effectivity, we can include it here. Okay, thank you. Something that Ana Paula mentioned that is in the evaluation sheet, advances are also measured. If a state is part of an initiative but does not have a law for protection but is advancing in this area, okay, it does not fulfill with the indicator, but they have advanced so much in fulfilling it. For example, they have a bill in Congress, the technical assistance from UNHCR has been received, etc. My question was that the state agrees to participate in this mechanism. They have 3 months to provide the information, but you already responded the question. So this can be complemented with the implementation of new elements that maybe a bill has been passed, etc. Yes, this is a live tool. If a state says we want to do something different, welcome. Every 4 months, welcome, because we are advancing so fast that every 4 months they will have to reassess. Well, wonderful. But when I say 3 months, it is an initial evaluation just to provide with a term. It is not that there's a need for 3 months. If one state does it in 1 month, okay. If they do it in 6 or more months, it's also okay. The idea is to provide with a tool, not to put pressure on the state to be filling in reports. The idea is to have a good baseline so that the state can have a tool when working in this. And as mentioned earlier, it is different when we deal with the human rights reports. There are deadlines to be able to respond within a certain period of time, and if you don't do it, then you're late, etc. If it is used, it's wonderful, but if it doesn't get used, it will be just lying around there. What we will see after the break is how we see the operational plans of the UNHCR. The idea of receiving the support of UNHCR will be the operations aspect coming from the office. If the state is interested, then we have to consider the agenda of the UNHCR in its own activities. With regard to the birth registry, which is what we're concerned with in some countries, it can so happen that there is base information that does not necessarily exist in the state, or that there is contradictory information from different agencies in the state, and we'll have to find a certain solution. And something else is that for federal countries, the responses will not be uniform. Depending on the jurisdiction, the response will be different. So we will have to find a certain balance here, so that there are certain countries that will see different assessments. Maybe that would be something complex for the certain countries of the region. Yes, I agree. We'll be seeing this in practical terms, learning from what we find in practice. What is positive is also having Luis here, is that there is more joint work from many offices in the region with different national registries to prevent statelessness, and not only at level of country but at regional level. We're also working in this area. We will be holding a conference of national registry offices in Latin America and the Caribbean. We had the opportunity last year to meet with them, and they gave us 1 day to be able to talk about statelessness and the national registry offices. There's also some information included in the OAS, and UNHCR was not always involved the way it is presented here. It was always involved in refugee registry, in the vital data registry. Even if there is a lack of state, the UNHCR does this. It has the tools for it. But maybe the area in which we are linking these subjects to statelessness, it is more of a newer area. There is not much information in the region yet.
Bueno, entonces yo los invito ahora, ya son las 10.
I would like to invite you to a coffee break, and thank you very much.